The story of Joshlin's disappearance from her Middelpoort home in February last year has gripped the nation. The alleged involvement of her own mother, her boyfriend and their two friends sparked community outrage. During a trial within a trial, Rhyn and Appollis' lawyers argued that statements they made to police in March last year were inadmissible. The court ruled otherwise. Rhyn's lawyer today submitted that the state has no case against her client. She has described the investigation into the child's disappearance as poor and asked the court to reject the evidence of the state's star witness, Lombard, who she painted to be a serial liar.
The state has two versions before this court. Joshlin being taken to the White Polo, Joshlin being taken to Makalima. In the White Polo, we're told that he went with a woman that is described as Sangoma wearing a red cloth or a red dress. In Makalima's place, we're told that there was a man with a red shirt. Division of the proceeds in 204 statement was going to be done by one of the co-accused. In the story of the T-shirt, there was a story of 5,000. But this story of 5,000, my lord, is not corroborated by anyone. Either the story of the T-shirt. These are the versions that are before this court. I humbly submit before this court that the state has failed dismally to prove its case beyond reasonable doubt, and that the defense has a right to choose if they want to remain silent. They won't ask permission from the state for that right. I'm referring this to the case that was referred by the state of Busak. I request my client not to be convicted on these charges.
The state contends that this case is the first of its kind in South Africa and an important one for jurisprudence. This because usually in a trafficking in persons case, the main source of information is the victim, while in this case, Joshlin is still missing. It says Joshlin was deprived of her freedom and that human trafficking amounts to modern-day slavery.
Who are the exploiters who are exploiting Joshlin? We want to know. In which place? She has to tell this court. She didn't. For 4 hours, 30 minutes, I was listening patiently for the state to prove its case beyond reasonable doubt. No compelling evidence before this court, no strong evidence before this court suggesting that my client committed an offense of trafficking in person, kidnapping, and any conspiracy.
Smith is alleged to have planned the so-called sale of the child as far back as August 2023. Her friend, Lombard, who turned state witness, testified that she told her she sold the child to a Sangoma for 20,000 rand. While the state concedes that Lombard's evidence is open to criticism, as she admitted to have lied, it says her evidence was corroborated by, among others, that of evangelist Steveno. He testified that Smith told him that her children would be taken away and that she would accept 5,000 rand if the people did not have the 20,000 rand. Her lawyer, however, contends that Kutsia's evidence should not be relied on.
And I submit, my lord, that because of the passage of time and the attention that this matter got, he received information, and as time progressed, he adapted his version or what may have been said to him. And coming back to the law, my lord, I submit that he was a single witness in this instance also. although he did relay his version, according to him, Ms. Smith is the only one who explained to him what the plan was. And for that reason, his evidence should be treated with caution. And I submit that the court should reject his version on what has just been said, in view of the fact that the witnesses who should have corroborated it do not. And there are 3 witnesses who say almost the same thing, but none of them mention the most important things about what was said to him.
He says with all the evidence produced, even if the court finds some kind of corroboration, that does not prove the case against Smith beyond a reasonable doubt. In its reply, the prosecution maintains that it has a strong case against the 3 accused.
My Lord, my submission is, even if, and this is only with regards to Ms. Smith, because yes, we're alive to the fact that the confessions or the statements and the contents is not admissible against her. But Stephen could see her, corroborated by the reports made afterwards. His demeanor, his character. There is no way that that man made this up and fabricated this. My argument is, my Lord, there's absolutely no way that he would want to put himself in this position and come and testify about this. Why? There's just absolutely no ground for an argument that that was a fabrication and seek of fame. The person seeking the fame was Miss Smith. Definitely not Mr. Coetzee.
Judge Nathan Erasmus has ruled that the first 2 rows of seats in the venue be reserved for family members of the accused and the missing child. He is expected to deliver judgment at 10 a.m. on Friday morning. Vanessa Puna, SABC News, Cape Town.